Hello everyone, I'm Rich Swank, the Associate General Counsel of Florida Realtors, and I'm here to talk today about two contract changes that are going to go live on Friday, February 27th, 2026. Now these are fairly simple changes, so we decided to do just a very short recorded webinar rather than the normal live webinar we would do. So what are these two changes? Well, both of them were caused by statutory or rule changes. The first one, which is a little bit more elaborate, is the FinCEN rule change, which was originally found in Section 18I, Romanet 3 of the FAR and FAR as is contracts. The second one is Addendum EE qualifying improvements, which used to be the PACE rider. And these are the two changes that will go live on Friday the 27th. I'm going to go over the FinCEN rule with a little bit more detail because it's a little bit more elaborate. Now, for those of you who don't know, FinCEN is the Financial Crimes Enforcement Network of the U.S. Department of the Treasury. And one of their primary purposes is to root out money laundering. Now, previously in the state of Florida, we had what was called geographic targeting orders, where a specific area had to provide additional information, counties, cities, whatever, to determine whether there was money laundering going on. On March 1st, this rule is expanded nationwide, okay, and has essentially the same effect. Now, what I'm going to go over here in just a minute, I've pulled from the website fincen.gov/RRE. So if you have any additional questions or want to do additional research, this is the resource you would go to. So just to let you know, this rule was originally supposed to go into effect on December 1st, 2025, but it got delayed until 2026 and will go live on March 1st. And on March 1st, FinCEN will require the filing of a real estate report on any reportable transfer, which is defined in the final rule as a non-finance transfer, to a transferee entity or transferee trust of an ownership interest in residential real property. The first thing to notice about this is that it does not apply to all real estate transactions, only those that fall under the ambit of the rule, all right? So, as I said, it replaces the geographic targeting orders and now goes nationwide. The definition of non-finance transfer is a transfer that does not involve an extension of credit to all transferees. Broadly speaking, that means cash or hard money lender transfers. So if a transfer is mortgaged, this rule will not apply. The transferee entity is any person other than a transferee trust or an individual. For example, a transferee entity may be a corporation, partnership, estate, association, or limited liability company. So in other words, if the transfer is to an individual, someone who is readily identifiable as a person, then again, this rule does not apply. It does apply to residential real estate, which, as we know in Florida, generally means a structure designed principally for occupancy by 1 to 4 families, or vacant land on which the transferee intends to build such a structure, all right? Now, what party information is required? Well, the whole idea is to be able to find out whether money laundering is going on, so most of the information that's required is to drill down into the entity that is receiving the property. So the first thing that's required, the transferor, then the transferee entity or transferee trust, the company, LLC, or whatever, the individuals representing the transferee entity or transferee trust, and, this is the important, information sufficient to identify the beneficial owners of the transferee entity, including name, date of birth, residential address, citizenship, and taxpayer identification number. So again, the individual beneficial owners of the entity, that's what they're looking for, okay? Now, who must report? I have to warn you, this is pretty dense, all right? But again, this is pulled completely from the website. If you've talked to a closing agent over the last few weeks, okay, you probably have heard about this. It's what they call the reporting cascade. And essentially what happens is if the person in number 1 exists, then they have to do it. If the person in number 1 does not exist, then number 2 has to do it, etc. So settlement agent, and if no settlement agent, then the person that prepares the closing statement. If neither of those is present, then the person that files with the recordation office. If none of those is present, then the person that underwrites an owner's title insurance. If none of the first 4 are present, then the 5th one, the person that disperses in any form, including from an escrow account, the majority of the money. If none of those 5 are present, then the person that provides an evaluation of the status of the title. And if none of those are available, then the person that prepares the deed. Now, what you'll notice about this is that it does not explicitly say anything about real estate agents. They are not explicitly part of the reporting cascade. If, as part of your duties, you perform something like this, okay, and this applies to you, I do invite you to do additional research to find out about this. But otherwise, for the most part, it does not involve real estate agents, all right? Now, that said, there are criminal penalties if this is not complied with. So it is in everybody's best interest to cooperate as much as possible with whoever must provide the report to get the information to that person so they can file the report and not delay closing, all right? So what exactly changed in the contract? This is the old version, okay? Again, Section 18I, Romanet 3, talks about the FinCEN geographic targeting orders that I discussed earlier, okay? That is fairly straightforward. It's been there for years, all right? Now, the new version, which goes live on February 27th, but the rule which goes into effect on March 1st, talks about the real estate reporting obligation. You can read the entire thing. It's very straightforward. There are a couple of parts you should pay special attention to. If this transaction requires completion of a FinCEN report, then seller and buyer shall, no later than the day prior to closing, provide closing agent with all information and documentation necessary to enable closing agent to complete the FinCEN report. So in other words, the buyer and the seller have to provide that information we talked about earlier. Each party agrees to promptly provide and consents to closing agent's collection and report of said information to FinCEN. All right, this may be sensitive information. In fact, it is likely to be sensitive information, and the parties may not want to give it up. If they sign this contract, they agree to abide by this rule, or by these particular rules, if the rule does apply. Now, the last sentence is probably the most important for purposes of the contract. Because it affects primarily the buyer, the transferee entity as we discussed, then the buyer shall pay all costs and fees charged by closing agent to prepare and file the FinCEN report. And these could be significant fees. So make sure you check with the closing agent ahead of time how much it's likely to cost. And that's all there is with respect to the FinCEN rule change. Again, broadly speaking, does not apply to all transactions, generally does not apply to real estate agents, but everybody cooperating with it will facilitate the implementation of the rule, and closing can go forward as normal. Now we'll get on to the next one. Next one's much, much easier. All right, we're talking about Addendum EE, the Qualifying Improvements Rider. All right, it was formerly the PACE rider. PACE was Property Assessed Clean Energy Program. In other words, some companies were able to provide essentially clean energy, solar panels and the like, with a lien against the property, which was then paid with non-valorem assessments. All right? This rider, again, has been part of the contract for several years. Last year, the legislature amended Section 163.081, particularly subsection 163.081, subsection 8, all right, to require a disclosure when there is a qualifying improvement. Essentially, all they did with respect to this rider was change the name from PACE to qualifying improvements, all right? So when you have a situation that requires it, you're going to use this rider. And again, if you want to go back and do it side-by-side comparison, which you certainly can if you like, you'll see that the language is virtually identical, except for the fact that it is now called qualifying improvements and not PACE. And that's it. That's all I have for you today. So if you have any additional questions, please call the legal hotline at 407-438-1409. And I hope you have a great rest of your day. Thanks.